We've built the program by concentrating on the strengths that Bucerius Law School and UC Hastings Law School each have to offer, particularly in the fields of international law, intellectual property law, and the law of technology and innovation in general.
So we selected this topic of licensing because licensing is sort of a bread and butter skill for every IP transaction practitioner.
It's important to recognize that the civil law and the common law traditions take different approaches not only with respect to conventional subjects like contract law, but in some cases have very different views on the intellectual property regime. And it's critical for lawyers who are going to operate in an environment where both civil and common law can affect their transactions to understand the differences between those systems and how they affect our ability to transact intellectual property. The program starts by giving students a common foundation about the basics: contract law, intellectual property law, competition. We then move on to telling students about the practical aspects of international licensing. What sort of clauses are included or not in the agreement? What are the common practices in different industries like software, music licensing, or the pharmaceutical industry? And then the final element, the capstone of the program, is to give students hands-on training in negotiation skills.
We had the opportunity to visit both Google and Airbus. And the interesting thing was that we were allowed to get quite an insight into how these companies work from an IP standpoint. At Google, we had a presentation and a meeting with the attorney who does music licensing for YouTube. And of course, the students were extremely receptive. They're all familiar with the setting. At Airbus, we had discussions and actually a workshop on innovation incentives and on how to strategize international patent licensing.
We've assembled an international faculty that takes advantage of the strengths of not only renowned academics from Europe, the United States, and the United Kingdom, but critically practitioners as well, who practice in specific areas of intellectual property licensing in the software industry, in the pharmaceutical industry, in the music industry, or in trademark law.
I think the strength of the program was the integration between the theoretical teaching and the application. So students had 2 weeks of theoretical teaching. And then there was a workshop. And that workshop applied all the concepts that had been presented in the theoretical part. To supplement the normal curriculum of law schools by offering a program that is highly skills-oriented and practice-oriented, and that offers skills training to the students. I thought the students were extremely impressive, academically strong and very diverse within the group. So there were young practitioners, upper division students, some were doctoral students, and so on. They came from 15 different countries, and it was just a joy to observe how they interacted. I thought they benefited tremendously in their interaction, or rather from their interaction within the group. They benefited from knowing each other, from sharing opinions, from working together, and I think that was a key component of this program.
We've been really impressed by how the students are able to take what they learned in the classroom, the theoretical concepts, and apply that in the context of the negotiation sessions.
They were supervised by attorneys from major law firms, and the outcome of each negotiation was then discussed. I think it went extremely well.